It's like, yeah. Mr. Speaker.
The Honourable Phil Goff.
If I was a gentleman, I would have sat down. Mr. Speaker, the Labor Party is supporting the third reading of both of these bills, and we do so after careful consideration and reflection on the need for them, and indeed the impact that they have on the rights both of not just potential victims, but people who are very likely to become victims, and those who are the offenders who nevertheless may have completed a prison term. We call these cognate bills because they're parallel in their objectives, though they are different in the manner in which they achieve them and the consequences for those who are so affected. What they have in common is that they are, in both cases, dealing with individuals who have committed and been convicted for serious sexual or violent offending. What they have in common is that they're dealing with those people at the time they have completed a sentence which is a finite sentence, and in the normal course of events they would have been regarded as having done the crime and served the time and been released into the community. They are different, however, in the way in which they operate. The Public Protection Orders Bill deals first of all with probably the most serious group of people due for release but who are highly likely to offend. We're not talking about a large number of people, we're talking about maybe 5 to 12 people over a 10-year period. So we're talking about 1 to 2 people a year. These are people that have committed a serious sexual or violent offence. They are individuals that are regarded by the health professionals who have been working with them in prison as being of extremely high risk. And not only is that risk very high, but they are regarded as being in danger of imminent offending. Imminent offending in the bill is defined as the person is expected to commit such an offence as soon as he or she has the suitable opportunity to do so. And unfortunately, sir, there are people in the community that come within that category. In the normal course of events, if the judge has enough information in front of him or her at the trial of that individual, they would have committed those individuals to preventive detention. That is an indeterminate sentence. That is, they can be locked up forever, and if they are released at any point, they can be recalled at any time. But in this case, in these cases, the judge did not have that information. I'm not blaming the judge. Sometimes that information only becomes available after the behaviour of the individual has been observed by professionals in a prison environment over a long time. Mr. Speaker, the fact is we can avoid the consequences of these people offending, and that's what this bill is designed to do. There is a conflict of rights. Offenders do have rights, and that should be recognised, but so too does the rest of society. And in particular, sir, I draw your attention to the fact that the most likely victims in the circumstances covered by both of these bills are our most vulnerable citizens, our kids. And we owe it to them, if the prospect is imminent and very high and the consequences are appalling, we owe it to them to extend the protection we can to them against that happening. The individuals concerned in the Personal Protection Orders Bill will be in secure detention, but they will not suffer the same loss of rights as other convicted criminals. They're still free to vote, they're free to have access to the media, they're free to receive communications and visitors, they are free to work and retain the earnings, or they're free to get a benefit and would be eligible for a benefit. So what that actually highlights is that this is not designed as a punishment. This is designed for the protection of the safety of the community. In that sense, sir, what we're trying to do in these bills is very similar to what we do under the Intellectual Disability Act and the Mental Health Act. These are cases where people are detained. They're not regarded as criminal, but they're detained because they're regarded as being of danger to themselves and to others. Mr. Speaker, the second bill is the Parole Extended Supervision Orders Amendment Bill, and that works slightly differently. It deals with a much wider group of people. It's a an act that has already been in existence and it's being extended. Indeed, 10 years ago, I passed the Parole Extended Supervision Orders Act, and that dealt with people, was focused on one category of people, those who were serious sexual offenders against children. And what it did is that when the prison sentence, a finite prison sentence, came to an end, it allowed extended supervision orders to be exercised that placed those individuals under close supervision thereafter. I know exactly why that bill was enacted, and if I had the same opportunity, I would have enacted that bill again, sir. On the information that I had as then Minister of Justice, it was critical that we provide protection against individuals who had no ability to control their behaviour and no empathy with their victim or understanding of the impact of their actions on the victim. And that makes the situation very dangerous indeed. Many of them were of low IQ. All of them were people who could not be given rehabilitation within prison that actually worked. Programs like Kia Marama and Te Piriti are excellent at dealing with people who are child sexual offenders, and in most cases they can deal with people and they can substantially reduce the risk. This is a category of people who will not be affected positively by engagements in those sort of communities. These people are not detained in prison, they're in the community, they're under heavy supervision. But because they're being dealt with under the criminal law, this law, again as it did in 2004, breaches the Bill of Rights Act according to the opinion of the Attorney General. I never lightly support legislation that breaches the New Zealand Bill of Rights Act. But in this case, sir, again, I believe that the rights of the people who almost certainly will become victims comes first. The bill allows us to extend indefinitely supervision orders if they are required. It also extends the category of people covered by it from sexual offenders against children to sexual offenders against adults and very serious violent offenders. The largest numbers will be still against those who commit acts against children. And regrettably, we need it. Again, people could have been sentenced to preventive detention. They weren't. But if the judge knew when he'd made the order what the prison authorities and the health professionals know at the end of the sentence, the judge, he or she, most certainly would have done that. Mr. Speaker, I think both of these bills are necessary. We could have actually manipulated the system to try to bring in civil orders in this case. It would have had no impact in material terms on the situation that the offenders find themselves in, and in the end we neither had the time to do that, nor did we want to run the risk of changing a system that seemed to be working very well. There are safeguards. Judges have to make the orders, health professionals make the assessment, the parole board reviews. I think we've got the balance of rights correct. I think both pieces of legislation are necessary and are important to protect the rights of New Zealanders and particularly our children.